Hi, my name is Jay Shore. I'm a certified Americans with Disabilities Act advocate and have been for about 8 years. And this is one of the most egregious stories I've ever put out about a judge. I'd like your opinion on what you think of this. A 100% service disabled veteran gave a Tennessee court notice of his disability 4 times. Here's what the court did with that repeated notice. And I'm going to tell you how insidious it actually is. When Mr. Cohen first got up to approach the podium to start in with opening statements, he carried a cane, a weapon. He said it right over here. The next time he got up, miraculously, he didn't need it, and he didn't carry it back to the podium with him. Sometimes it's the things that you see when you don't leave your common sense at the door that helps you know how bad situations are. The weapon was a cane. It belonged to a disabled veteran, a veteran that had already told the court, in writing and out loud, exactly who he was and that he is disabled. Watch the order this happened in. The notice always comes first. On April 9th, 2025, Mr. Cohen, a 100% service-connected disabled veteran with a mobility impairment and a hearing impairment, gave this court notice of his disability in writing by filing a motion to quash. In that filing, in his own words, he described himself plainly. The systematic nature of this fraud inflicted severe harm upon respondent, an already vulnerable disabled veteran, resulting in significant emotional, financial, and reputational damages and unjust interference with his parental relationship. That notice went into the court's own file 3 full weeks before the hearing, and it was not invisible to the judge. Because at the start of that hearing, the judge himself raised Mr. Cohen's pro se filings and offered to hear them. And then Mr. Cohen gave notice of his disability verbally when he said, drawn solely from my disabled veteran benefits. Then, with that written notice sitting in his file and hearing Mr. Cohen say that he was a disabled veteran, he would later say this about whether he had been told about a disability.
There was no in-court notice given by any party on that date of a disability.
Here's what the ADA says in its implementing regulations. 28 CFR 35.137A. Use of wheelchairs and manually powered mobility aids. A public entity shall permit individuals with mobility disabilities to use wheelchairs and manually powered mobility aids such as walkers, crutches, canes, braces, or other similar devices designed for use by individuals with mobility disabilities in any areas open to pedestrian use. A cane is one of the most single recognizable signals of a mobility disability in ordinary life. Every reasonable person in that room, and certainly a judge, knows what it means. That is notice. Would a reasonable person receive 2 notices, one in writing, one orally, and see someone with a cane, a third notice, and be without the ability to deduce easily and readily that this person has a disability? That's a question I want you to answer. When the chancellor says no notice was given, hold that against the court's own record. Notice was given in writing 3 weeks early. It was given orally on the day. And Mr. Cohen walked with a cane. You decide how no notice of a disability survives that. Then, with a written filing on record, an out loud disclosure in open court, and a cane in plain view, the chancellor looked at that mobility aid and reached for a different word. He carried a cane, a weapon. And here's how we know that classification of that cane as a weapon was not about security or, in the chancellor's words, common sense. Because every reflex that classification would have triggered didn't happen. Let me show you. If it had been a weapon, the bailiff would have been ordered to seize it. He wasn't. If it had been a weapon, security would have logged it. Nothing was logged. If it had been a weapon, the man would have been detained, charged, or warned. He never was. And finally, if it had been a weapon, opposing counsel would have raised it. She never did. Not once. The word weapon did no safety work. It did 100% rhetorical work, taking a disabled veteran's mobility aid, the very thing he had given notice about, and making it sound sinister. Stay with me here on this cane because the cane was the notice. A man with a service-connected injury used it to reach the podium, then set it aside. Anyone who lives near or around a mobility condition knows these conditions fluctuate. One minute you have to use the aid and the next moment you don't. That's the most ordinary thing in the world. And then the court took that ordinary fluctuation, that notice of a real variable disability, and called it a miracle. The next time he got up, miraculously, he didn't need it, and he didn't carry it back to the podium with him. Miraculously. The court didn't see a disability it had been given notice of. It diagnosed deception by eyeball from the bench with no doctor, no opposing counsel making any reference to the cane, and a federal disability rating classifying Mr. Cohen as 100% service-connected disabled, sitting in the file. A medical conclusion the court was never qualified to make, dressed up as common sense. The fourth notice came during the hearing itself, 3 separate times, out loud on the record. Mr. Cohen gave the court notice of a second disability, his hearing impairment, and asked for help. Mr. Cohen says, "Your Honor, I'm sorry, I'm having trouble hearing what's being said." The Chancellor acknowledges and says, "Okay." Mr. Cohen says, "Is there a way to turn up the PA?" The Chancellor says, "Can you pull that just a little closer to you? There you go. It should work. Speak up just a little." A little. Let me be clear. The request for turning up the PA was a request for an accommodation. And the implementing regulations of the ADA says that primary consideration shall be given to the request of the individual with a disability. But this court did not do that. This court asked the opposition to speak up a little. It did the minimum effort instead of ensuring that, to the maximum extent possible, individuals with disabilities receive the benefits or services provided by the public entity. Did the court ask anyone to repeat what had been said? No. Did the court ask the court reporter to read the testimony back? No. Did the court ask Mr. Cohen how much he'd missed? No. Did the court ask Mr. Cohen if he needed an accommodation? No. Here's the court's entire reaction to a disabled veteran saying he could not hear the case against him. One word. Okay.
If you say, "I cannot hear," and I ask the witness to speak up, that is a reasonable accommodation.
So Mr. Cohen had to do the court's job for it. He asked directly for the PA to be turned up. Microphones were right there. Did the court turn it up? No. By April 15th, 2026, there was nothing left to be unsure about. Standing in front of the same chancellor, Mr. Cohen gave notice in the fullest terms possible. Service-connected, enlisted at 17, VA adjudicated, mobility impairment, hearing impairment, the entire document record laid out loud and in writing. Then, with all that notice in front of him, not in hindsight, not by surprise, with every fact on the table, this is what the chancellor chose. And this time it's not just a photo and a transcript. This is him.
Frankly, this court is insulted by the picture drawn by Mr. Cohen today. Frankly, the court stands by its conduct and its ruling within the proper context. The court stands by its inferences drawn on the record on that day about the case, about the cane, and about its place as a weapon. The court will not step back from the way that the cane was displayed upon that day, the place that the cane was displayed upon that day, and the manner in the way that it was placed on that day in light of the knowledge that the court had that day. Respectfully, Mr. Cohen, if I had all the knowledge that I had now, I may not have drawn that inference.
Let's hear that again.
Respectfully, Mr. Cohen, if I had all the knowledge that I had now, I may not have drawn that inference.
He admits out loud that with what he knows now, he might not have called it a weapon. He concedes the inference may be wrong, and in the same breath refuses to fix it. But remember the spine of this whole story. The knowledge wasn't new. The notice came first, April 9th in writing, April 30th out loud, and in plain sight. He had a cane with him. He laid it down beside the podium. That's all he did. He didn't shake it at the judge. He didn't raise it up at the judge. He laid it down beside the podium. The only hindsight added was a judge admitting he'd rather keep a finding he concedes might be false than correct the record for a disabled veteran.
And lastly, this motion is frivolous.
So in the end, the chancellor said this motion that Mr. Cohen brought to correct the situation was frivolous. And then he punished him. He awarded attorney's fees for the opposition. And so here's the whole story in the only order that matters. A notice was filed. Then the court claimed no notice of a disability. On April 30th, Mr. Cohen said it out loud, walked in with a cane. Then the court called the cane a weapon. Then the cane signaled a real variable disability. The court called it its non-use a miracle, even though this was only something Mr. Cohen has to use intermittently, and at that time, especially because he didn't have shoes he was waiting on from the VA. Mr. Cohen said, I can't hear 3 times in the record. Asked for the PA. The court says okay and told the witness to speak up just a little bit. So he filed a motion to reconsider, and the court said, that's frivolous. I'm going to make you pay the cost. And the court says it stands by calling the cane a weapon and will not step back from it. In this video, I wanted to show you the facts of what people have to deal with in court and how someone who didn't know how to tell the court they needed accommodation did the best they could. And actually, case law says there are no magic words to invoke the ADA. The court should have had a notice that Mr. Cohen had a disability from his filing, from his oral statement, and from him walking in with a cane. And then again with the motion to reconsider, stating it all again on the record, the court said, hey, I stand by what I said.
Frankly, the court stands by its conduct and its ruling.
This is a judge and a chancellor who doesn't want to back down from their decision. And so this matter is on appeal, and Mr. Cohen is also suing this court in federal court right now. And I wish him well with it. So I'm going to leave the last word to you. Tell me what you think in the comments.